Hey folks, John Cantera, the Double Broker Bounty Hunter here, and thank you so much for joining us in our next installment of our fraud prevention series. This is part 11, insurance fraud. Now, do you know the different types of insurance fraud that exist out there across the transportation industry? You might think you do, and it is a massive topic with a great number of what ifs. Well, those what ifs depend on a lot of different things. Now, at the end of this particular series, actually, not the series, at the end of this particular part, I do have an expert that I'm going to pass on to you. You can tell them that Double Broker Bounty Hunter referred you to them, but they are the absolute expert in the different kinds of insurance out there for transportation and of different situations. In fact, they serve as an expert witness in court dealing with insurance matters. So this is a good guy to get to know, but we'll get to that here in just a few minutes. Before we get down to the nitty gritty of insurance fraud, we got to go with a word from our sponsors at AccuBid Pro.
Do you know your cost per mile? Have you been hitting your profit margins? Do you struggle with bidding in a way that is both profitable and competitive? Would it be worth it to have all this information right in front of you? By calculating your cost per mile, AccuBid Pro helps you stay profitable in an industry still struggling to recover. In order to calculate your cost per mile, AccuBid Pro asks you questions about your business expenses. Our goal is to help you understand what you need to keep operating in order to keep up with the game and maintain your business. Enter your origin and destination, and we show you what you should bid based on your personal cost per mile in order to be profitable, even including a more detailed breakdown of each bid. Download the app today and get your 30-day free trial of AccuBid Pro, available on the App Store and Google Play. Bid smarter, bid faster, bid better with AccuBid Pro.
I'm sure you've all figured out by now that this series is not designed to be the end-all be-all of what goes on in the transportation industry with regard to fraud. However, it is supposed to be a guide to help point you in the right direction when you do have issues. So please make sure you take it as such. In the meantime, let's go ahead and get this party started by talking about some of the different types of insurance that exist within the industry. Now, mind you, this is not a comprehensive list. This is just the most common things to think about. Okay, so let's start with the brokers. And the brokers typically have a $75,000 surety bond, and that's the minimum required under MAP 21. MAP 21 is the law that delineated the requirements between brokers and carriers and defined double brokering, et cetera, as we all know. I won't get back into that mess. However, that $75,000 surety bond is a requirement. The other kinds of insurance that brokers require are not required, however, highly recommended that they invest in because of different situations that may come up. One is contingent insurance. Now, contingent insurance for a broker basically helps to cover them when there are situations where they are uninsured, or if there's an issue of overages on a claim that won't be covered by a carrier's insurance or whatnot. Basically, it's a catch-all that helps to protect a broker from a catastrophic claim that may come from a shipper. Another one is errors and omissions. E&O is what that's referred to. And E&O is basically CYA, cover your ass insurance, because CYA insurance is absolutely critical. If a broker sits there and tells a carrier, okay, here's the issues, boom, 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 and boom, but they failed to mention either on the rate confirmation or in discussions that the cargo had to be tarped. The cargo wasn't tarped. It was taken off to wherever. It rained a little bit. The cargo was ruined as a result. The broker never said anything. Well, this coverage will help protect the broker on that claim, because the carrier is certainly not responsible for it. The carrier was never told it had to be done. This will help protect the brokers. So brokers, it is highly recommended that you spend the money on the contingent insurance and on the E&O. As long as you have all that, you should be in decent shape. Now, carriers, I know you guys get the brunt of the stick every single time, and this is no exception. There are so many different types of insurance that carriers need to carry in order to, one, function, and two, to protect yourselves from that catastrophic nuclear claim that gets handed down. First off, the requirements: vehicle liability, $750,000, as we all know. But that's only FMCSA's requirement. Most brokers that are out there are after that $1 million. So remember that. As for the cargo side, you're required to have a minimum of 75,000. Again, look at broker requirements. That's usually 100,000 plus. You also are required to have bobtail coverage. And for those who don't know what bobtail coverage is, bobtail protects your tractor when you have nothing attached to it. This also goes for the hot shots and the box trucks that are out there, even sprinter vans. This helps to protect you when you are empty. So it is important to have that bobtail coverage. Interchange coverage. Now, this is only for tractors. Specifically, if you use loadout trailers, then you're going to have interchange coverage. And that interchange coverage does vary. Different brokers require different levels. I have seen it as high as 50,000. I've seen it as low as 20,000. So set a level that you're comfortable with, and then you can work with whichever brokers you can that operate up to that level. General liability. I'm throwing that in here under the carriers, even though brokers can enjoy general liability as well. General liability coverage covers non-vehicle incidents. For example, you're driving around in your truck and you get into an accident. Well, that's where your vehicle liability comes in. General liability doesn't kick in for that, but general liability will kick in if your driver is standing on the dock at a shipper and slips and falls and gets injured as a result. That's a non-vehicular related incident. Therefore, your general liability will pick that up. That is why it is important to maintain general liabilities, and more brokers these days are requiring that. And that is not to protect them, but more to protect you, the carrier, and by extension, their customer, the shipper. Of course, E&O also applies to carriers here. I know when I was a carrier, I did carry E&O insurance, and that's if I screwed up and I didn't tell my driver that they needed to do this, that, and the other, then I was protected from liability and was covered. It's basically cover your ass insurance. And that's one of the great things about insurance. It protects you. However, as much insurance as required in this industry and as important as it is to help protect us, it is one of those things that people try to find ways around to skimp on in order to try to save money. And that leads to insurance fraud. So let's go ahead and start breaking down some of the various issues that exist within this realm. So the first question I have is, are you underinsured? And people say, well, hey, I've got the $1 million vehicle liability. I've got the $100,000 cargo. I'm good to go. Well, to a point. Now, as I dispatch hot shots, I have to be conscious of the value of the cargo that I'm putting on, because I take several LTL loads and I try to mash them together in order to get as much revenue per mile as I can. And as a dispatcher, that's always the name of the game, maximizing revenue. But if that truck was engaged in an accident and the cargo was destroyed, that $100,000 cargo coverage is only going to cover the entire cargo. It's not going to cover each individual load at 100,000 each. So if you are hauling a total value of 150,000 and you get into an accident, your insurance is only going to cover 100,000. And then there's going to be a war between the shippers, the beneficial cargo owners of the different cargo, as to who's going to get paid out and how much are they going to get paid. You want to avoid those issues because they can get ugly. So know the value of the cargo that you're hauling and make sure you are covered for the total amount of all cargoes on your deck, especially if you are a hotshot. Now, the same thing does go for dry vans. If you mix partials and LTLs, know the values and be insured to cover the whole thing. Brokers, we always worry about brokers being underinsured. And I kind of already touched on this a little bit when it comes to their surety bonds. Are they overexposed? And in most cases, they are. I have seen in some instances where medium-sized and large-sized brokers had upgraded their surety bond to as much as $10 million. Well, for brokers who are doing that, bravo. But if you're one of the big 3-letter brokers, 10 million's a drop in the bucket. You do $1 billion worth of freight every freaking year. I mean, is 10 million going to be enough? Usually not. They expect the carriers to carry enough insurance to insure absolutely everything that's on that truck. So why aren't we expecting brokers to carry enough surety coverage for all the freight that they handle over a period of time? I mean, $75,000, that's maybe about 10 minutes at TQL. Maybe. Certainly not an extended period of time. Does your insurance have exclusions? Now, I'm willing to bet if I step up to a carrier and I say, what are the exclusions on your policy? You're not going to be able to answer the question, because you need to have that thick book of a policy that is your entire coverage. And you need to figure out how much of that are exclusions. And I'm willing to bet more than 50% of it, if not 75% of that stack of paper, is a list of exclusions. Know your exclusions. Know what the common exclusions are. Know what the problems are, where you could find yourself in a hole if you're hauling certain types of freight. I'll give you an example, and it's a very common example. If you are a hotshot or a flatbed guy, and you run with Progressive, or you have Lloyd's of London as your cargo insurance, you're going to get rejections from occasional brokers because Lloyd's of London and Progressive both have policies that indicate that they do not cover cargoes that have been tarped and then moisture gets in underneath the tarp. This is especially prevalent on Progressive. So you see a lot of times, if you're on a load board, you'll see in the notes, no Progressive insurance. That's why. So you need to know what the exclusions are, whether it's a company policy or that's an exclusion specifically designed for you, the carrier, because these policies are custom. There is no cookie cutter way to do it. So you need to have a very good relationship with your insurance agent to make sure you are getting all the coverages for all the types of cargo that you haul. And when it comes to liability in turn for cargo claims fall under something called the Carmack Amendment. And Carmack, very simply, basically delineates the liability. It also says, again, very, very simply, that brokers are just a party to the transaction and really are not involved in any kind of a cargo claim. Therefore, when a carrier makes a delivery for a broker, You get a signed BOL back, indicating it's no longer in the carrier's possession. The carrier has completed the contract. Regardless of the condition of the cargo, the carrier has completed the contract. The carrier deserves to be paid. Brokers are not supposed to withhold the freight bill from the carrier because of a pending claim. That is a violation of Carmack. Now, let's dig a little bit deeper into Carmack, because Carmack really deals with generalized claims. Unfortunately, a broker's agreement can supersede Carmack. Let's break down Carmack just a little bit more so you have a general idea. The carrier must be paid by the broker on delivery regardless of a potential claim. I've already mentioned that. And carriers are to be presented, claims are to be presented to a carrier's insurance company, not to the carrier, and it should be done by the shipper, not the broker. Okay, so again, the broker's not supposed to be part of it. And the reason why the broker's not supposed to be part of a cargo claim is because they never had possession of the cargo. That BOL denotes legal possession, and that legal possession is where the claimants exist. So you have the shipper who hands off the cargo to the carrier, and that's utilizing a BOL. While the carrier is moving the cargo, they are in physical possession of the cargo. That BOL denotes they have that physical possession. And then when the BOL is signed as received, the carrier is no longer in possession, the receiver is. So it's all about who is in possession of the cargo as to who has specific forms of liability. The broker is never in that chain. The broker should never be paying an insurance claim to their customer ever. They're not responsible for it. Unless, of course, their contracts deem that otherwise. And there are some shippers out there who are very savvy about that and pass liability that they would normally have onto the brokers. And there are brokers who don't pass that liability on to carriers. And it's all about contracts. That's, like I said, gets to be a very messy topic. That's why when you are dealing with a claim, you want experts working with you to help you understand where your true liabilities are. And it is embedded in those carrier agreements, in those shipper agreements. So you have to pay attention to what it is that you sign. So when you do have an issue in a standard situation of a claim, a broker is only responsible for feeding their client information. Okay, they give all the information about the carrier and their insurance COI to the shipper. The shipper then engages with the carrier's insurance in order to file the claim. And then it is up to the carrier's insurance to accept or deny the claim and provide the necessary grounds. The broker, again, has no skin and no mechanism to hold a carrier accountable. Therefore, the freight bill must be paid if the cargo is delivered and accepted. As long as that cargo is sitting on the truck, no payment needs to be made to the carrier. But when the cargo is off the truck, payment must be made and cannot be withheld. Again, this all changes when it comes to contracts. However, we do see a trend in claims where brokers, because they're not happy with the result of what the insurance company is telling them in a cargo claim, decides to strong arm carriers into paying claims themselves without insurance by filing a freight guard against them for an unresolved claim. This is an inappropriate use of freight guards. If a carrier gets a letter back from their insurance provider saying we are denying the claim, the carrier is not liable in any way for this damage, then the carrier is off the hook. You cannot hold them accountable. And if you attempt to sue a carrier in court for liability, well, now it's up to the courts to try to determine, okay, Are they liable or are they not? But they will take the insurance company's word most often as to what liability or who has what level of liability in the incident. In most cases, those court cases never even see the inside of a courtroom. There's usually some kind of a settlement for joint liability, but that's neither here nor there. But the important thing with when it comes to these freight guards is to make sure that if the carrier provides that information to their insurance company and they cooperate with the investigation, what are they hiding? There's no subterfuge. If there's subterfuge and they're trying to hide stuff from the broker, okay, now you've got grounds for throwing a freight guard on them for an unresolved claim. But if they're being forthright, they're giving all the information, and the insurance company denies the claim, says they're not liable, don't throw a freight guard on them. Because if you do throw a freight guard, the carrier can turn around and sue you for defamation and cause you all sorts of problems. Guys, freight guards are serious, serious things these days, and they cost a lot of money. And if it ever goes to court and you, Mr. Broker, end up losing in court, we're talking hundreds of thousands of dollars in damages. Okay, even possibly millions, depending on the kind of loss the carrier takes as a result of your freight guard. And let me tell you something, a lot of brokers don't take too kindly to freight guards about claims. They will immediately reject carriers on those claims and not read the information that is contained in the freight guard comments. So be very careful about those freight guards. If there's subterfuge involved, if the carrier's lying about things, now you've got grounds. But you have to be very careful about that kind of thing. Now, I've talked a lot about insurance and how claims function. Let's get into the fraud side of it. And again, this is a very general topic. We're just scratching the surface, but this is to help get people aware of what's going on in terms of insurance fraud. Are you an owner operator working with a carrier, or do you have a black cat as a supervisor who likes getting in your way when you're trying to do informative videos? If you are an owner operator working for a carrier, our first recommendation is to verify your coverage. You need to make sure that your coverage that your carrier tells you have actually exists. You have the right to call the insurance provider, provide the policy number, and make sure that your equipment, that you as a driver are included on the policy. Because if you're not, and you're in an accident, you could be liable personally for everything that's going on. Guys, some carriers, if they are hard up for cash, may tell you you are protected, may generate a fake rate confirmation indicating that you're protected, but you're not protected. And if you're not protected, you could wind up in a whole world of hurt. So make sure your coverage is in fact valid. Okay. It's not about distrusting your employer. It's about verifying, because lots of employers are cutting corners when it comes to this kind of thing. Make sure they are doing it right, or you are the one that suffers. If you are a broker screening a carrier, make sure you get an updated COI. I can't say this enough, and our expert will tell you the exact same thing. A COI is only good for the date that it's issued. You may sit there and look at the COI and say, hey, wait a minute, the policy doesn't expire for 6 months. Well, that's true. The policy may not expire for 6 months. Get him out of my way because he is driving me insane. The policy may not expire for 6 months, but the carrier the next day can call the insurance company and said, okay, pull that truck off the policy. I'm selling that truck, or I fired the driver, or whatever. They can do whatever to reduce their insurance cost, their total cost. And if they do that, and then there's an accident, then suddenly the cargo's no good. So even on a multi-day cargo, okay, you may have a COI for the 12th, you pick up on the 12th, and it delivers on the 14th. But on the 13th, they cancel the policy for whatever reason, and the truck's in an accident, the car goes destroyed. Oh, there's no coverage. But I got a COI from just yesterday. That doesn't matter. Get a COI from today. So I know that's a lot of hoops to jump through. And whether or not you as a broker are comfortable with the risk of saying, he's not going to cancel the insurance policy over the next 24 hours, so we're going to let it go. If you're comfortable taking that risk, great. But if it happens, it's you, Mr. Broker, who are screwed. I'm just saying from a liability standpoint. So you have to protect yourself. Protecting yourself means you have a robust compliance group who is constantly checking on policies for active loads to make sure nothing is changing while the load is in motion. I know it's a pain. I know it's torturous, but it's the only way to ensure that you are, in fact, fully covered for the duration of the load. If you are a carrier and you're trying to screen a broker, verify the bond. Because as long as you have an outstanding debt up to when the load is delivered, that bond needs to be in place. Now, if you deliver, the company goes under 2 days later, you can still be a party to the bond. You can still file on the bond and you should be able to collect your piece. But if there's already $2 million on a $75,000 bond, how much are you actually going to get when you file on the bond for non-payment? Not much. I believe it comes down to 4 cents on the dollar in that particular situation. It's ugly, but know whether or not the broker maintains an active bond coverage. And if you can determine how much there is in claims against the bond, that would be helpful as well. In most cases, you're not going to know if there are outstanding claims against the bond. You really want to know is just to make sure that the bond is in fact active. If the bond is active, you should be in a good place. But again, it's all about risk. Can the broker cancel their bond the very next day? You damn skippy they can. And especially if the broker is going out of business very, very suddenly. We've seen it happen, folks. If you are a carrier and you're just scraping by, there is a temptation to try to minimize your liability by cutting back on your insurance policy. Because let's face it, insurance is a huge part of the cost for a carrier. It could be as much as 25% of your operating cost. On average, it's like 15% of your operating cost. It all depends on your driver's driving record, their MVR. It depends on the age of the equipment, the value of the equipment, et cetera, et cetera. So many different factors go into the rate. But if you start devaluing your truck in order to pay less insurance, you could get caught with your pants around your ankles. That is a part of fraud. If you have a fleet of vehicles and you take 10% of your vehicles off your insurance, well, now 10% of your fleet is uninsured on the road. That is a huge gamble if one of them gets into an accident. You know, again, that is insurance fraud. If you are a carrier that employs owner operators and you have them paying you $300 a week or whatever to cover their part of the premium for insurance, and then under your contract, you're supposed to provide them insurance, there's a temptation to not provide insurance for them and to pocket that money. That is insurance fraud. And again, these things will catch up to you at a criminal level very, very fast. Do not play games when it comes to insurance. Is the insurance industry broken? Yes. Does insurance cost way too much? Yes. However, it is an absolute necessity in this industry. You cannot cut corners here, because cutting corners will cause a catastrophic judgment against you at some point, and not only wipe out your business, but can wipe you out personally as well. It's not worth the risk. And if you're committing fraud, now you also have to deal with the criminal element of what you are doing. You may think what you're doing is innocent and there are no victims. That is not the case. Pay attention, make sure you're keeping up with your policies and that you're not keeping yourself uninsured or underinsured for the operations that you are dealing with. I said before, this is a very, very, very complex subject. So to honor that complexity, I want to offer our friend Drew Wilder. He is with Vicarious Liability Risk Management. He is the absolute expert. Please reach out to him if you have a claim issue or if you have claim questions. His knowledge is absolutely invaluable. Reach him at Drew3 at VLRMGT.com, and he will be able to help you out with whatever your issues are. Drew, I'm sorry I didn't get permission to put your information out there, but I'm throwing it out there because you are the very best insurance expert that I am aware of. So huge props to you, my friend. With that being said, we here at Vigilant Transportation Services, we are happy to help in anything that you need when it comes to dealing with fraud in the industry, regardless of what that fraud is. And if we're not able to help you in terms of recovering funds related to the fraud or something along those lines, it's okay. Still reach out to us because we can at least include all of your data into a database that is then shared at FMCSA, DOT, and other stakeholders across the industry so that we can form and visualize the different webs of scams that exist out there. We are part of a new organization called the Freight Fraud Task Force. Hashtag Freight Fraud Task Force. Look at it. Look for it on LinkedIn, Reddit, Facebook. We are constantly putting out new information about the task force. But if you ever need help, this is my information. Please don't hesitate to reach out to me. Get me at jcantera, vigilanttransport.com. Call me. My phone number's on the screen. Hit me up through my website. There's a messaging function on there as well. We are here to help. Now, for the shameless plug, for us, as you know, our podcast, Stop the Scam, is live every Monday, 5 p.m. Central on all of the Lounge Media Group social media outlets. Be sure to check it out. You can always reach the hosts, myself, Jay Cantera, stopthescampodcast.com, or my co-host, Kate Price, at kprice@stopthescampodcast.com. But stay safe out there, and whatever you do, don't let scammers take you for a ride. We'll catch you next time.